Welcome to this evening's session on the EU settlement scheme and citizens' rights in the UK post-Brexit. So my colleague Caroline, who is helping with the slides and all the technical know-how, is said to me that the sound is all good. So we'll move on with the this evening's debate or discussion. For anyone who has joined us before, welcome back. For anyone joining for the first time, welcome this evening. Just to introduce myself, my name is Chris Ben. I'm an immigration lawyer with a firm of solicitors called Seraphus. Seraphus has worked along with the EU Commission and the EU delegation to the UK on matters relating to citizens' rights for several years now, and part of the work that we do involves outreach and information provision to ensure that citizens are aware of their rights in the UK post-Brexit, and to address unfortunately, some of the many complications that have arisen. Brexit, obviously, a very complicated process and involved a big change for those citizens who had made their homes in the UK. And so we have tried, and the delegation to the UK is always trying to make sure people have as much helpful information about the situation as possible. And part of the work that we do involves outreach, and this is a format which we can hopefully reach people and engage directly and receive feedback from yourself. So that's the idea of these monthly Facebook Live sessions. We do them on a monthly basis, surprise, usually at the end of the month, not always, but we advertise them in advance, so do keep an eye out. And we're very happy to receive suggestions about what types of topics might be useful to explore and discuss. And we get feedback and questions throughout the month in between the sessions, and that we use that to sort of direct ourselves to try to make the session as relevant to people as we can. It's a really simple format we use tonight. I will deliver a presentation, not many slides, just on a sort of chosen topic that we recognize is something that might people want to discuss more information about. And then the second half of the session is just open questions, and people feel free to ask anything. It doesn't have to be related to the topic that the slides show is about. It can be about anything to do with citizens' rights. I'll always do my best to give the information. Sometimes I might not be able to answer, but I might be able to steer in the right direction. But yeah, it's a chance to ask anything. So feel free, type away, use the comments box. My colleague Caroline will pick them up and we'll address them after the presentation. So that's the idea. Really simple format. We usually go for around an hour. We won't finish any later than 6:30, I would imagine, and that's usually plenty of time to cover what we need to. So to move to the topic of discussion, it's a long title this evening. I'll explain. It's a little bit more straightforward, I hope, than the title, but we're talking about rights, and we're talking about rights that are attached to the EU settlement scheme and the withdrawal agreement, which is the agreement between the EU and the UK that sort of implemented Brexit. It implemented the breakup, or the UK exiting the European Union, and it provides for the rights of citizens who were living in the UK by the end of 2020. That's the key date as far as Brexit is concerned. That was the end of EU law in the UK. And it also protects British citizens who are resident in EU member states, as there are estimated to be around 1 million Brits who were resident around the EU. So it affects a lot of people. It affects a lot of Europeans living in the UK because we are into the multiple millions. It was sort of estimated originally 3 million. We're up to 5.7 million grants of status under the settlement scheme to European nationals. So somewhere the estimates weren't quite accurate, and it's more and more people have been affected than were originally expected. So it's really important. I'll explain a little bit about why we're focusing on rights under the withdrawal agreement, because it's something that actually we've had requested to talk about, and because I think there's been quite a lot of confusion for anyone following the UK media and press in the last month or so. There has been an awful lot of stories about migration and about the direction that the UK government, the Home Office, is travelling as far as migration is concerned, and it's caused, I think it's fair to say, it's caused confusion, and in some cases has caused quite a lot of concern. And so what we want to do this evening is to address those concerns and hopefully try to make people feel a little bit more reassured about their situation, because the EU settlement scheme does sit in a very unique space within the UK immigration system, which I'm going to come on to when we work through the presentation. So just to give you an overview, what I'll do, I'll explain what it is that the EU settlement, where does it sit in the immigration system, why is it so unique, and then we'll talk about rights and what rights do people have when they have EU settlement scheme status, and then we'll look at proving those rights, because it's one thing to have rights, it's another thing to prove them and to be able to exercise those rights without impediment. And then I'll cover complaints and complaining about rights if they're not being upheld, because unfortunately, as I say, it's one thing holding rights, it's another thing to actually be able to exercise them. And unfortunately, it does happen that people are prevented from exercising rights that they have. And so we'll talk a little bit about that situation. And then I'll come to the part that I was sort of the press speculation and the discussion in the media has really focused around this immigration white paper, this proposals from the government, which will be implemented by the Home Office and other government departments, mainly the Home Office, about the direction of travel for UK immigration policy. And what I'll aim to do is tie that back in with where I'm starting, which is about rights under the settlement scheme, because as I hope people will be reassured, the white paper really doesn't have a great deal to say about the settlement scheme, and many of the proposals in that white paper will not affect people who have EUSS status. So let's go on to the kind of like the part that I guess excites lawyers like me, and about what's the legal source of rights. And this really is important. It's important for the settlement scheme. It's important for people with pre-settled and settled status, and that is because the settlement scheme sets out the immigration status that is given to EU citizens and family members who were living in the UK before the end of 2020, before Brexit took effect. It is pre-settled status. Settled status is an immigration status. It's technically known as pre-settled is called limited leave to enter or remain, and settled status is known as indefinite leave to enter or remain. Indefinite meaning settled, permanent status. So they are immigration statuses. They are provided for by UK immigration legislation, which says this is what non-British and actually non-Irish nationals. Irish nationals have a special situation, but essentially people who are not British need to have an immigration status to live in the UK. So the EU settlement scheme gives European nationals an immigration status. It gives their family members an immigration status. And the rights that come with that immigration status are also provided for by UK legislation. So something like the right to work, which everyone with pre-settled status and settled status has, is something that is it is provided for in legislation. The right is created by a piece of legislation that's attached because it's a condition of the immigration status that you're allowed to work. So that's where the settlement scheme is a kind of, it's implemented by domestic UK legislation. But, and this is the really important but, unlike almost all other immigration statuses given to under other immigration routes, the EU's settlement scheme is giving rights to people that are guaranteed in the EU-UK withdrawal agreement. So even though the settlement scheme is what we would call like a domestic, it's a part of the what's called the immigration rules, which are domestic UK policy. But the rights that are being given via the settlement scheme are rights that were written down in the withdrawal agreement between the UK and the EU. It just means that the rights that are in that agreement, the way the UK gives those rights is using this domestic EU settlement scheme. But it's important to remember that, and it's important because the withdrawal agreement is an international agreement. The rights that are contained in the withdrawal agreement are agreements of rights between the UK and the EU, and they should be respected as an international agreement. And this means that the withdrawal agreement has something called direct effect in UK law, which means essentially that the rights contained in the withdrawal agreement can override other pieces of UK domestic legislation if those pieces of domestic legislation conflict with a right that is given by the withdrawal agreement. Essentially what happens is the domestic legislation is just it's not acted on, or it has to be changed in some situations. And so it's really important to remember that, because when the UK proposes changes to things like immigration policies, and we'll come back to this at the end, when the UK proposes those changes, if those changes for people who are protected by the withdrawal agreement, so if people with pre-settled settled status, if something that the UK proposes about future policy is incompatible with the rights under the withdrawal agreement, and for people with pre-settled and settled status, who are those people with rights under the withdrawal agreement, the proposed changes that the UK is making will not affect them. They will not. They'll either be like a carve out in the proposals that the UK puts forward, which says, oh, by the way, this doesn't apply to people with pre-settled or settled status, or if for some reason, and sometimes mistakes are made, if the legislation is not written to make those with settlement scheme status protected, then it's possible that the courts would step in and create those protections. So it's really important that when you hear about announcements and policy changes and things like that, to have that at the back of your mind, that actually the rights that you have if you're under the settlement scheme, they are protected by the withdrawal agreement, and that means that things that are incompatible with your rights will not happen. It doesn't. I think what we'll come back to the way that the proposed white paper on immigration, how it doesn't talk about the settlement scheme, and I'll come back to this point of why it doesn't talk about the settlement scheme, because it's tying in with what we're thinking about here, which is the idea that the withdrawal agreement rights are superior to any kind of policy changes. So that's the kind of legal basis. That's the technical stuff. It's the boring stuff, unless you're someone like me. But I wanted to make it clear, because a lot of the questions that we've had since the white paper have been saying, well, what do I have? Like, how is the withdrawal agreement protecting me if the government is proposing to make changes to immigration policy? And that's how the withdrawal agreement protects people, by being superior, being an international agreement. Okay, so that's where the rights come from, how they work in UK law. But it's important, obviously, to understand what are the rights that the settlement scheme provides, that the withdrawal agreement provides. Most of the rights come through the status, pre-settled or settled status. The main thing, obviously, that is most important to people was the ability to carry on living in the UK after Brexit took effect. Before Brexit, European nationals living in the UK would have been in the UK under Free Movement Directive, under the Citizens' Rights Directive, as it's called, free movement laws. But after Brexit, the settlement scheme status took over that. So as long as you've got settlement scheme status, you have the right to live in the UK. It's really important for people for European citizens living in the UK before the end of 2020 who haven't yet secured status under the settlement scheme. It's really important that they make a late application. You still can make an application to the settlement scheme to get this pre-settled or settled status if you can justify the reason for applying late. And we do still, even though it feels like we're a long way away from the end of 2020, actually there are still people making late applications because not everyone was aware of the scheme. So there are still a lot of applications made that are late, and people did get granted status. So that's just if you come across someone who's from the EU living in the UK by the end of 2020 who for some reason doesn't have status under the scheme, tell them about making an application, direct them towards we've got a website that we'll give the address for throughout this evening, and go to that. It tells you how to make a late application. It tells you what you need to do. Okay, so residency obviously is the main right. The rights of your family members to also have residency, and that includes family members living with you in the UK already, and for eligible family members who aren't living with you at the moment, they can come and join you in the UK in the future, and that is your right. That's something you have for life, your family members. So if you were married to someone, your marriage took place before the end of 2020, but your spouse doesn't live in the UK at the moment, maybe they have an overseas job, you have the right, if you are a European with pre-settled or settled status, you have the right to sponsor your spouse to join you in the future when the time is right for you. They are an eligible family member. You have that right to bring them to the UK. So that's the residency side. Obviously, part of residency is being able to exit and enter the UK. And so when you travel back to the UK, if you have settlement scheme status, then you do not need an electronic travel authorization. You already have a permission to come to the UK, which is your pre-settled or your settled status. So you don't need an ETA. You don't need to apply for one. You don't need to have one just in case things go wrong. You do not need an ETA. You have pre-settled or settled status. And you can also, as well as your passport, you can use your national ID card to travel to the UK. And that's an important right, because after Brexit, the UK changed the policy for European nationals coming to the UK to say, no, you have to use your passport. You can no longer use your ID card. But because the withdrawal agreement protected the EU nationals already living here, because that has to be given effect by the settlement scheme and pre-settled and settled status, if you have pre-settled or settled status, you can carry on using your national ID card to travel to the UK, and that's your right for life. We'll probably talk a little bit later in the year about the types of ID cards that can be used, because there could be a change in that, and we want to prepare people. We won't talk about it today, but it is that you are able to use national ID card for travel. If you're going to use it, link it to your UKVI account. I'll talk about that on the next slide, to make sure that the Home Office is aware that this is a document you want to travel with. Okay, working, self-employment and study. So I've already talked about the right to work, and it's the same with self-employment, running your own business. That you are essentially without restriction. You can do those economic activities in the same way that a British citizen can do. And in terms of studying, if you're going to go to university or any kind of higher education, you are eligible, in the majority of cases, you'll be eligible for home fees on the same basis that someone with British nationality is eligible for home fees. So different devolved nations apply different rules for student fees. So there's not a universal approach between England, Wales, Northern Ireland, and Scotland. So you do have to check where you're living. But the general principle is you're entitled to have home fee status because you have pre-settled or settled status. You're entitled to rent property. Owning property is generally not restricted by any kind of immigration status. But renting property is something in England that you would not be able to do without having an immigration status. And so when you have pre-settled or settled status, you're entitled to rent property. Landlords or letting agents will carry out a check on your status before renting to you. UK residents can access the NHS, and by UK residents, I'm talking here with UK residents, including people with pre-settled and settled status. The reason I've written it as UK residents is because in some situations, if you are a British national but you do not live in the UK, you are not entitled to access the NHS for free. And the same would apply if you have settled status but you don't live in the UK, then you may not be entitled to free treatment. But on the basis that the majority of people with pre-settled and settled status do live in the UK, you have access to free NHS treatment. So that's really important, because people without pre-settled or settled status, they have to pay quite a lot of charges to the NHS, either through what's called the immigration health surcharge for people with visas, like working visas, or if people don't have a status, then they are they're subject to overseas charges, which are very high. And so having access to the NHS for free is a really important right that attaches to pre-settled and settled status, as long as you are also resident in the UK. You're also, unlike a lot of immigration statuses, you're eligible to receive benefits, and so I'm talking things like universal credit, and also other types of social welfare, homelessness assistance. There's no barrier on making those claims based on your immigration status, because pre-settled and settled status you're entitled to make those claims. I've put in brackets subject to meeting conditions, because it is a bit trickier to make a claim for something like universal credit if you have pre-settled status, because you do have to show that you are eligible to receive it. And this is based on something called a right to reside test. I won't go into this in great detail, but yeah, there is a sort of barrier that applies to pre-settled status holders, which means not everyone with pre-settled status could get universal credit. If you have settled status, you're entitled to universal credit on the same basis that a British national would be. So it's not that everyone can claim universal credit, because there's certain eligibility criteria that do kick in. But the point is, for someone with settled status, is you're treated the same as a British person who is claiming universal credit. And the last thing about just to cover with rights is obviously based on any national insurance contributions in the UK, you can receive a UK state pension, but also because the withdrawal agreement has written into it something called social security coordination. That means that if you have, before you moved to the UK, if you had made pension contributions, state pension contributions in your home country or in another country around the EU that you worked in, then they are amalgamated and you are paid. You can use those other pension contributions before you came to the UK to receive a full a UK state pension. So you can use the kind of qualifying contributions. It's a little bit of a complicated area, but the principle is that you don't have to start again making pension contributions each time you move to a new country within the EU. So and that applies to those protected by the withdrawal agreement. So if you're in the UK and protected by the withdrawal agreement, your right to accumulate your pension contributions around the EU is protected. And it also means that if you decide to leave the UK to retire somewhere else, then you can receive your UK pension paid to you in another EU member state, or outside the EU. But if you're receiving it when you live in another EU member state, then your pension is increased each year in the same way it is for people who live in the UK. So social security contributions and coordination is very, very important for people who are protected by the withdrawal agreement. So that's an overview of rights. I mean, this is obviously, you can imagine, this is a very broad overview. There's lots of detail that comes with this, but we just want to make sure people have a clear awareness of what those rights are. I'm sure most people are aware of how to prove pre-settled and settled status, but we always want to reiterate it because it was a big change how the settlement scheme brought in this new type of way of proving immigration status, which is a digital online status that didn't exist before the EU settlement scheme. And so it has been a big change. It's been a change for people holding status. It's been a change for people like employers and landlords who have to deal with immigration status. So it has been a big change. Digital immigration status is now the sort of default of the Home Office. So it's not just people under the EUSS, the settlement scheme, who have digital status. Many others do as well. So people are getting more used to it, but it can be challenging to use digital status. It's not been totally smooth, the rollout of digital status. But the key to your digital status, of course, is accessing your UK visa and immigration account, which is shortened to UKVI. And it's important that you can access that because you need to go into that account to be able to generate something called a share code. And you need, if you want to change, like update your passport because you've got a new passport or a national ID card, you need to be able to go into the update functions within the UK VI account and carry that out to make life easier when you're traveling. So it is important to be able to access it. As I say, most people do find it straightforward to use, but it can be a challenge if you're not used to kind of digital functionality and things like that. When your digital status is being checked, there are essentially two ways that this will happen. I mean, there are sometimes other ways, but the main ways that people will check status is either you give them a share code. So this is like an employer. If you go for a new job and an employer says to you, I need to know that you have the right to work in the UK, permission to work, then you can give them a share code, which they check via like an employer website, which links to the Home Office, and then they get the confirmation of your pre-settled or settled status. So that's where you give the information to an employer or a landlord or a university or a bank. So like quite often private entities will use share codes. But there is also for some government, mainly government services, there's something called like an automatic API check. So what it is the government body that you are engaging with can check with the Home Office your status without you needing to give them a share code. So for example, if you claim universal credit, then there is an immigration status check to make sure that you're eligible to claim, like that you're not prevented by your immigration status. And so the DWP checks with the Home Office says, yes, this person has settled status, and then the DWP should move on with your claim, knowing that you have the correct immigration status to move to the next stage of the claim. So that's like you don't have to do anything. That is when the public body checks automatically with the Home Office. There are other ways that sometimes people have to rely on to prove their status if something isn't quite. If it's usually when it's not something's not working. Sometimes people can show their profile within the UKVI account with your picture, and it says you have pre-settled or settled status. That sometimes people will accept that. Sometimes people can use the letter sent by the Home Office saying, we've granted you pre-settled or settled status. It's not really an official way of proving it, but sometimes it can be a way of showing that you have status. The reason why we sort of highlight this is because unfortunately the reality of the digital status is it doesn't always work. It does work in a lot of cases, perhaps even the majority of cases, but it doesn't always work. And if it doesn't work, then that can be a problem, because you need to be able to access your rights. And if your rights are online, but something is not working online, then you can, you're in a difficult position. I mean, think probably the most common issue that we see is to do with traveling, where people aren't able to prove their right to travel to an airline or someone like that, because that's something you need to be able to do that in real time. There's not really the option to say, well, if the system doesn't work, I'll try again tomorrow, see if it's working, because you need to travel in an hour and a half. And so there's a lot of pressure in a situation like that. So it's just to say that it can, the status, that might be part of the issue. Sorry, I think we potentially lost the I've just been asked to pause. Okay, I think we're back. There you go. We were talking about online issues, and lo and behold, we had an online issue. Just to say, like, the reality of digital products is that they don't always function as they should be. The Home Office has various ways in which you can communicate with them about any issues, and they should make every effort to fix any issue as quickly as possible. Gov.uk, if you type in e-visa and gov.uk or Home Office, you will get the pages on that, and they have guidance about how to report issues and how to raise problems if there are any. Obviously, we hope people don't have them, but the reality is it does happen. Okay, in terms of, we want to make people aware of complaining about issues to do with rights, because, as I say, like, the rights are attached to the digital status. If the digital status doesn't work, then you might not be able to prove your rights, or people might not accept that you have rights. So if that does happen, then you would want to be able to raise a complaint and to have your situation looked at and resolved. You certainly wouldn't want to indicate that everyone can sort of resolve every issue that arises to do with rights with pre-settled or settled status, and that everything sort of will run smoothly, or you'll be compensated for every inconvenience. It doesn't. Unfortunately, that's not the way the world works. But there is, importantly, there is a body set up by the withdrawal agreement in the UK called the Independent Monitoring Authority, the IMA, who are their role is to protect those with rights under the withdrawal agreement, and to make sure that people are able to enjoy their rights. So it is a really important body, and part of the work that they do lots of different streams of work. But one of the things that they do is receive complaints from people if a public body has breached or potentially breached withdrawal agreement rights. Public body is quite important there, because they generally will not engage with private entities about rights, but it depends on what the situation is. But the point is, if you have had an issue, if you have had someone, if there has been someone who, or a public body who you think has not upheld the rights that you have under the withdrawal agreement, you are able to report that to the IMA. They will carry out an assessment, and they'll tell you whether or not they think it's something that needs to be kind of investigated further. So it is a really important body. It only exists for people who have rights under the withdrawal agreement. So it is it's definitely worth reporting issues, using the complaints process, because that's one of your rights as someone under the withdrawal agreement to complain to them. And the more information they have from people, the better they are able to do their work, because They need to understand where might be problems with people's rights. It doesn't. In some situations, it may be necessary to complain to the public body who has caused an issue. It might be the Home Office, for example. It might be an issue at the border, which would be complaining to Border Force, a department of the Home Office. So you can raise complaints directly with public bodies using their processes. In many cases, you might also want to report it to the Independent Monitoring Authority. So to sort of have a double approach to try to rectify what's happened. In some cases, it might be a private entity who has caused you difficulty, and that may present more of a challenge in terms of complaining and trying to get redress. But there may be processes. I'm thinking of like airlines as a good example, because if an airline, for example, has stopped you traveling to the UK because they didn't think that you had the right to travel to the UK because they didn't check your pre-settled status or your settled status, then that may be something you can claim compensation for, because denied boarding, if they've denied you boarding incorrectly when you do have the right to travel to the UK, that would be something that the airline could be held liable for, and you could have compensation paid. So that's just one example. I've just used it because it's quite a useful example, because we know that there are sometimes issues with airlines bringing people to the UK because they don't quite understand how the UK system works, particularly since electronic travel authorization has now been introduced for European visitors. So that is a way of complaining. I wouldn't be able to sort of cover all of the ways that people might be able to complain about rights, but it's just to give a sense and to raise awareness that this independent monitoring authority does exist for people who are under the withdrawal agreement. I think my colleague Caroline has been posting the website that we have fleshed out as much of this information as we can, including a page on complaining about rights and giving a bit more guidance. So even though we can't cover in loads of detail in the presentation, hopefully, you can go and look at our website and see, and feel free to make suggestions about ways to improve the website. We want to give helpful information. So the final thing that we'll cover this evening is the immigration white paper, the government's immigration white paper that was published a few weeks ago. And this will bring us kind of full circle to where I started with the withdrawal agreement. Because and the white paper was why we sort of wanted to cover this topic this evening, because it has created confusion for people. So we want to try to help people understand what's going on. A white paper is essentially a sort of high-level policy paper. It's setting out possible ways that the government might look to change sort of law and policy, in this case about immigration. It doesn't sort of mean, in most cases, that the information in the white paper is not going to be changes are not going to come tomorrow. Some of the changes might come a little bit sooner than the others, but it's sort of more a looking ahead kind of document. And it also doesn't mean, just because it's in there, it doesn't mean that it will happen. That's the important thing. There may be changes to the way the government thinks. Priorities might be different in a few months' time, things like that. So just because it's written in the white paper doesn't mean it's going to happen. But of course, it is a statement of intended policy. So you should, we do take it seriously. Within the white paper, there is not a single mention of the EU settlement scheme, and this is where it comes back to where I started, which is the withdrawal agreement is what the settlement scheme, the rules that the settlement scheme has, are set by the withdrawal agreement. The withdrawal agreement says this is how long people have to live in the UK to be able to qualify for permanent status, for settled status. These are the family members who can be sponsored under the withdrawal agreement, and they're the family members who can be sponsored under the settlement scheme. So what you see in the settlement scheme is what's in a lot of senses. It's not, it doesn't mirror it perfectly, but that's why the settlement scheme rules are set the way they are, and that's why the white paper doesn't mention them. Because if, for example, the white paper, one of the things it does mention, it talks about potentially changing, is the length of time someone would need to live in the UK to apply to settle here, so to get permanent status. At the moment, in most types of immigration categories, like skilled worker, for example, you can settle after 5 years, the same as with moving from pre-settled to settled status after five years of living in the UK. So the white paper is proposing that this is extended to 10 years, in not in every case, but in certain categories. But it doesn't mention the settlement scheme. And the reason for that is because the withdrawal agreement says someone who's under the withdrawal agreement, a European citizen or their family member living under the withdrawal agreement with status under the settlement scheme, can qualify for permanent residence after 5 years of meeting the withdrawal agreement conditions. And so, because that's what the withdrawal agreement says, if the government said, well, actually, you only qualify for settled status under the settlement scheme after 10 years, quite obviously that would breach what the withdrawal agreement says, because it says 5 years. So that's why the settlement scheme is not mentioned in the white paper. And that's why essentially the majority of what is in the white paper does not have any impact on people with settlement scheme status, pre-settled or settled status. It doesn't impact because the rules of the settlement scheme are not set by they're not policy that's up for debate from the government of the day. It's an agreement that has already been made between the UK and the EU about the rules. So basically that's the kind of headline, is like, when you read about the white paper and the possible ways in which the government might look to reduce migration, or make people spend more time in the UK before they can settle, or make them pass higher level English tests before they can get immigration status, doesn't apply to the settlement scheme. It just is like not part of it. So so that's the kind of reassurance that essentially we want to provide to people. Sorry, I know that we've had a little, I think another buffering incident. But I think we're back. So the final point, just on the white paper, just I'll finish it, is about British nationality rules, because again, it's something that we've had quite a few questions about, because there is a proposal within the white paper to extend the time that someone has to wait before they could apply to become a British national. At the moment, the rules on British nationality are in a lot of situations, not every situation, there's different rules on nationality, but the main one for people adults wanting to apply to become British is called naturalization as British. And you can usually do that after 6 years, because you have to have a settled status before you apply for nationality. So in the case of someone under the settlement scheme, 5 years living in the UK, you get your settled status, but then nationality law says you have to wait for 12 months after you became a settled person, and then you can apply for nationality. So that's why I say it's 6 years. It's the 5 years to qualify to become settled, and then the 12 months after you become settled before the door opens on you applying for nationality. So that's the current situation. 6 years. It's a bit quicker if you happen to be married or in a civil partnership with a British person. Then, as long as you've been in the UK for 3 years, then you can apply as soon as you have become settled. So for someone under the settlement scheme, that would be mainly 5 years of living in the UK, because you'd qualify for settled status after 5 years, and because you're married or in a civil partnership with a British person, you immediately become eligible to naturalise. So 5 or 6 years is the usual qualifying time. The white paper is proposing to extend this to 10 years potentially. We will have to wait and see what this proposal looks like before we know to what extent it will affect people who are covered by the settlement scheme. It's a bit hard to say. That the policy is not very clear on this point at the moment. I guess if someone approached me and said, I've just qualified, or sorry, I qualify, I've already held settled status, I got it 2 years ago. I've been thinking about becoming British, but I haven't sort of done too much about it yet. What would be your advice? I guess I would say, well, if you think that becoming British is the right thing for you, because you don't have to become British just because you have settled status. You can just keep your settled status. There's no reason that you need to become British. But if that's what you decide to do because this is your home and you want to kind of become, sort of take that last integration step, I guess, then, and if you said, well, I've been here for 7 years. I got my settled status 5 years ago, so I've been here 7 years. So I'd say, well, you've got the 6 years that you definitely need. There's a possible proposal on the table from the Home Office to extend that to a longer period of time. So if you're ready to go now, probably do it, because because otherwise you don't know what might change, and you don't know. I mean, it's unlikely to change immediately because the Home Office is talking about consulting on this, but they are saying it will change at some point. So I guess that's how I would look at it, and to say, well, if it's something you're thinking about but haven't got round to sort of actioning yet, then maybe now is the sort of time to get a bit more active about it, because there could be a change coming, and obviously we'll explain those changes when we know about them and how they might impact on people. But yeah, if you wanted security, then I guess now would be the time to think about applying. So that hopefully is a bit more reassuring about what's this white paper that's generated so much media interest, and certainly we were asked to kind of explain a bit about what's going on from some of the comments that we received. So that's what we aim to do. I'm not sure if there's any questions that have arisen as we've been going through the presentation. We do. So I'll go through these now to make sure that we try to cover them. Okay, so the first one, hopefully, is, will EU citizens be able to apply for citizenship after 1 year with settled status? Well, I've just covered that. The rules right now say yes. We don't know what the situation looks like once if the proposals move forward. So if you're already there, good idea to do it. And the follow-up question, or the second question from the same person, is, can a child who just got settled status apply for British citizenship straight away, or do they have to wait a year like adults? Children are in a little bit of a different situation, because you cannot apply to naturalise if you are under 18. So there are different rules for children, and it's a little bit complicated. If a child is born in the UK, then generally they're going to be in a better position. When a child is not born in the UK, whether they can apply for British nationality can depend. So I can't really answer that question, but except to say that so a child would definitely, if it's what's called sort of a discretionary application to register the child as British, then the child having settled status would be important, but the situation of their family would also be important. How many of them have got British nationality instead of, so it's not clear. We can't definitively say what the situation for children is if we're talking about children not born in the UK. Children who are born in the UK who are not born British, if one of their parents becomes a settled person, i.e. get settled status, that child becomes eligible to register as a British citizen. They have a right to do so. So it doesn't even matter if the child hasn't got settled status. If they're born here, but they weren't born British, and one of their parents becomes a settled person, that child can apply to become British. Okay, so the next question is, what is the maximum legal time allowed for the Home Office to give a decision on a pre-settled status? Is a 4-year delay in giving the decision considered reasonable and lawful? It is a Surinder Singh route application, and they've asked me to talk about whether it's governed by the withdrawal agreement or the EU free movement law. Okay, so the first part is the length of time. I mean, 4 years is a long time to give a decision on an application. Is it lawful? It will depend. There is no time limit on Home Office processing applications. As in, there's not like a written time limit. It's like if it's after 12 months, that's unlawful. There isn't anything like that, but it might be unreasonable depending on the circumstances to wait for 4 years. So really, you need to speak to on a one-to-one basis to a lawyer to understand why does it look like it's taking that long? What's the impact of it taking that long? Does the Home Office have all the information they need to actually make the application? There could be lots of different things. And it might turn out that actually 4 years is not, well, or the opinion of a lawyer might be that it's not lawful, and it might be something that's worth challenging in court, but it will always be dependent on the situation. I can't, this isn't a forum to advise that specifically. In terms of Surinder Singh applications, it's a particular, so it's for everyone who's on the call, it's a Surinder Singh application under the settlement scheme is a particular type of application. It's where the sponsor is British, so it's not a European national who is sponsoring a family member. It's a British citizen who at some point lived in the EU, and it's not under the withdrawal agreement, and it's not under the free movement directive, because the withdrawal agreement doesn't cover family members of Brits, because that's, from the EU perspective, not something that the withdrawal agreement, the withdrawal agreement doesn't cover British people living in the UK. It covers British people living in the EU. But so the withdrawal agreement doesn't cover Surinder Singh, an EU directive, the free movement directive, even though the Surinder Singh the rules are based on that, and the settlement scheme rules are based on that also doesn't cover it, because it's essentially the Home Office decided to include Surinder Singh applications under the settlement scheme, but that's a domestic decision, so it's entirely governed by UK immigration policy. So the EU withdrawal agreement and the EU free movement directive doesn't have anything to say about Surinder Singh applications. Okay. Right, so 2 questions from one asker. The current rules regarding immigration include extending the time needed to permanently settle from 5 years to 10 years. Can this affect those who are just about to reach the 5 years needed to apply for settled status? I very much hope that question was posted before I talked about it, but to reiterate, those proposals in the white paper should not affect the settlement schemes. They should not affect the qualifying time for settled status. Okay, now or in the future, the settlement scheme rules for settled status are 5 years of UK residence. So the second question from the same person is, I've seen some people have said that you can be away from the UK for 6 months every year with pre-settled status, and you can technically apply for settled status at 4.5 years if you haven't had any absences in your final year. Because even if you were away for the rest of the year, it wouldn't matter at that point. So what they're saying is, if you've got 4.5 years of qualifying residence and you haven't had any time away, should you not just be able to apply and say, well, even if I have my 6 months allowance of absence at the end of those 5 years, can I just apply earlier? So the answer to that is, if you look at the settlement scheme rules, then they say when you apply, at the date you apply, you have been resident for 5 years. You have a qualifying period of residence for 5 years. So what that says to you is 4.5 years is not enough, even if you would be entirely within your rights to spend the last 6 months outside the UK. The rules say when you apply, you should have a 5-year qualifying period completed. So that's the answer based on the rules. Like yourself, I have heard of people say to me, I've been given settled status when I applied, and I applied at 4.5 years and I got it. So what you're saying is wrong. No, what I'm saying is right. The rules say you have to complete it 5 years. Does the Home Office sometimes sort of make practical decisions based on the situation? Perhaps. And that might be why people have seen grants of settled status at 4.5 years, but that's not what the rules say. So if anyone approaches me and says, when should I apply? I say, as soon as you've completed a 5-year residence period, you can apply, but not before. But because I've just said, in answer to the question about the white paper and the extension to 10 years settlement, not applying to the settlement scheme, you don't have to worry. You can complete your 5 years and then you can apply for settled status at the correct time. Okay. So there's a question here that says, do I think that is it possible to get settled status after being outside the UK during the COVID-19 pandemic for 2 years and 2 months? So what we have here is a situation where someone's had a very long absence from the UK, which probably has interfered with what would have been their 5-year qualifying period for settled status. So the technical answer to your question is it may be possible. The Home Office has a policy within their guidance that talks about absences that have exceeded 2 years because of the pandemic, but I think what the reality of what that policy reflects is that it would take a very strong case to convince them that absence is permitted. So yes, it is possible in theory. It's challenging. It's not something, I think it's something that you would want to do with a lawyer's assistance, because the case needs to be put very well and very strongly to the Home Office. So yeah, it is possible, but it is a challenge. And so I think, like, this isn't the forum to get into the individual kind of aspects. So, but yeah, you would definitely want to be talking to a legal advisor who understands very clearly the settlement scheme and how to present that kind of a case to the Home Office to make it convincing. So yeah, that's how I would sort of look at that. Okay. Again, 2 questions. Lots of people asking 2 questions, which is fine, of course. Will pre-settled status be extended for 5 years for everyone, or does the Home Office have certain eligibility criteria to get the extension? If so, what are these criteria? I'll come to the second question, which is related to pre-settled status, but not to the first question. So what the Home Office says is that they extend pre-settled status automatically before the expiry date without looking at any of the other conditions. So they don't look to see whether the person's been resident in the UK. They just say, you're coming to the end of your pre-settled status, so you will have an extension of 5 years to your existing pre-settled status. So that is what they say happens. There are situations that I've seen where the Home Office says we intend to let someone's pre-settled status expire. I've seen it in correspondence, so it exists. It doesn't really exist as any kind of policy that the Home Office, you can't point to any guidance on it. But it does. But I have seen it. So it's a little bit contradictory, I'm afraid, that the Home Office says on the one hand we always extend pre-settled status, and on the other hand, I know there are certain situations where they might not. But I guess what I would say, so what I would say is it will be very rare that the Home Office wouldn't extend pre-settled status automatically. If you have not seen an extension, then it may be quite likely that it's to do with a technical glitch, because that has happened. So you should contact the Home Office Resolution Centre and say, I haven't seen an extension, and so yeah, it should happen automatically, and it will happen in the vast majority of cases. There is no criteria to receive the extension. Okay, so the second question from this person is it okay for universities to ask for the expiry date of pre-settled status and ask for immigration records? Do they have the right to refuse enrollment if the status expires before the end of the course? That's a really good question. Universities are required by the Home Office to make sure that people enrolled on their courses have the right to enroll, as in the right type of immigration status, and therefore in principle the expiry date of pre-settled status would be of interest to a university. However, because there's a policy to extend pre-settled status, I would want universities to be aware of that, and to not certainly not to refuse enrollment. So I understand why universities might be confused about the expiry date and what it means for them, but they should be advised by the Home Office, in my view, that the pre-settled status is not like other immigration statuses in the way it shouldn't expire. I would say if you're experiencing enrollment difficulties with a university, or for that reason, that is something to report to the Independent Monitoring Authority, because the university is a public institution, and that means they're not doing the right thing. People with pre-settled status should have the right to enroll at university. So they have that right. I've already covered it. So yeah, so if that's something happening, I would suggest a complaint to the Independent Monitoring Authority with full details of the university and what they're saying, because that's something that I think that they would be encouraged to investigate. Okay, the last question that we have is someone whose mother has been in the UK since 1965. She has been refused EUSS, although she qualifies for a state pension. Her property is in her name in England, and her husband has been granted settlement scheme status. The problem is that she has many documents with different surnames, and previous employers in the 1970s committed fraud by using several national insurance numbers. So her case is not straightforward. She's in her early 80s and has health issues. The husband also has health issues. So it's right. I mean, okay, sorry. It is really distressing, and I'm sorry that this is the situation that you found yourself in. It's not right that if someone has lived in the UK since 1965, it is not right if they've continuously lived here that they should not be getting EUSS status. That's wrong. I can, like sometimes it can be hard to get documents if someone has had problems and things, but really there must be a way around this. Yeah, I mean, obviously, you've sort of finished the question saying you've been told it's a difficult case, and I do understand that, but yeah, there must. So perhaps you could contact the social media on the delegation. Perhaps you could contact My colleague Caroline should be able to put in an email address to contact the delegation, and then perhaps we can see if there's any organisation we can put you in touch with, because this doesn't sound right. So hopefully, I think that's the best way. This is not something we can deal with on this kind of call. It's not appropriate, but someone who's lived here since 1960 should not be struggling with the settlement scheme in the way that you've set out. So that's not good. Okay, I think that's all the questions. Sorry to finish on. There's a challenging one like that, but hopefully, the questions have all been helpful to talk about the discussion points, and hopefully this evening has been useful in that sense for people. Thank you for joining. Thank you for asking those questions. I hope that we've been able to clear up some of those more complex or concerning things that have arisen for people. As we said at the beginning, please do continue to use the delegation's social media channels to talk to us, tell us what's on your mind, tell us what issues are arising. We will always, we'll try to address them in the next time we join in June. So it's really, really, really important for us to hear from you. Thank you for joining this evening. I hope you have a good rest of the evening, and we'll see you next month, but communicate with us using the social media before then as well. Bye-bye.